I never see the lights out. They get me overdrive. Fancy on a fast car. This is how you make me feel. Don't stress me now. I got the overdose. I'm feeling it in my bones. And if you say that I'm lying to you, these habits are killing me. I wish I could fall asleep. The problem is you. Oh, I got the overdose. Oh, you are my overdose.
Hey, what's up, guys? On this beautiful Thursday afternoon, I read the new court doc, and it is very, very interesting. Some of the language that Ann Taylor uses in it was like, oh my God. Let's get into it, guys. Comes now Brian C. Koberger, by and through his attorneys of record, hereby submit this reply to the state's objection to his motion for change of venue. The pressure to convict Brian Koberger is so severe that Latah County survey respondents said if he wasn't convicted, they'd burn the courthouse down. Outrage would be a mild description. They would probably find him and kill him. There would likely be a riot, and he wouldn't last long outside because someone would do the good old boy justice. Enraged, strong opinions, firing of officers, riots, parents would take care of him, quote unquote. The parents would take care of him. The mob mentality within the community is the exact reason the statutory grounds prior to selecting the jury exist to move venue. Given these responses from potential jurors in Moscow and the state's acknowledgement that a remedy is needed for a jury to be selected, the state recognizes the obvious: an enormous venue problem exists. The state brings forth no experts to counter Mr. Koberger's, who are all clear venue must be changed in this case. The state does, however, acknowledge that Brian Koberger has a constitutional right to a fair trial with an impartial jury. Mr. Koberger's motion to change venue is supported with a memorandum, expert affidavits, declarations, and exhibits that preview the testimonial evidence the court will hear on August 29th, 2024. A rebuttal declaration of Dr. Dahire is submitted with this reply. On June 28, 2024, the Idaho Supreme Court pointed out that a change of venue is not an unreasonably high hurdle for a defendant to clear, but it does require proof of prejudice or a showing of reasonable likelihood of prejudice. The court is also concerned with the accuracy of the pretrial publicity, the extent to which the articles are inflammatory, inaccurate, or beyond the scope of admissible evidence, the number of articles, and whether the jurors were so incessantly exposed to such articles that they had subtly become conditioned to accept a particular version of the facts of the trial. The amount of media coverage in Latah County is the highest in the state and does not wane. There are more than 1,300 specific media stories covering Latah County. These stories are in print, digitally, and on radio and television. Media coverage continues, and the coverage is often inaccurate and inflammatory. The coverage conditions the potential veneer panel to think of Mr. Koberger as guilty, and that various bits of information are factual and support guilt. The media coverage inundating Latah County does not tell citizens that no evidence has been presented at this time, that there are no facts on the record at this time, that Brian Koberger is innocent, that only a jury decides what the facts are and whether the facts show beyond a reasonable doubt a person is guilty. Publicity regarding Mr. Koberger has been ongoing since December 30th, 2022. It rises and falls but does not wane. The media measured and presented the true scope in Exhibit C of the memorandum in support of change of venue, focused on traceable media. That means the media is in a particular location was measured, as is pointed out by the state in footnote 1, found on page 2 of its objection publicly regarding Mr. Koberger generating from YouTube. Publicity regarding Mr. Koberger generating from YouTube, Facebook, TikTok, podcasts, streaming services like Hulu and Netflix were not included in the True Scope report. Those highly inflammatory and prejudicial and inaccurate media forms reached Idaho citizens, but measuring them specific to locations is not possible. Hayden directs the court to consider media coverage in the current venue and logically venues considered as alternates. True Scope cannot measure the location of who reads Facebook, especially private groups, nor can it determine the location of who follows certain podcasts. These limitations do not change the data. Latah County, making up 2.57% of Idaho's population, has received 36% of its media coverage. This is the highest ratio in the entire state. Ada County, with the largest population in the state, has significantly less coverage per person. The state claims about the survey are wrong. Dr. Edelman designed the survey questions and how, depending on the participants' answers, the order of questions would flow. The survey report lays out the questions and responses for all 4 counties and demonstrates that the survey was conducted exactly the same way in each county surveyed. The only difference is the number of participants. The survey reports show the impact of media coverage. The more media items a potential juror knew, the higher the prejudgment for guilt. Latah County participants knew more media items than the other counties. The state criticized the content of the survey, complaining that not enough of the surveyed items were false, inadmissible, or false statements or information that this court must consider. What do you guys think about this one where it states they'd burn the courthouse down? Outrage would be mild. It would be a mild description. They would probably find him and kill him. There would likely be a riot and wouldn't last long outside because someone would do the good old boy justice, a hanging or a lynch mob. Enraged, strong opinions, firing officers. Riots, parents would take care of him. So that means that the parents would execute him themselves. Expanding the jury pool to Nez Perce County is not a remedy because the residents of Lewiston and Nez Perce are in the same designated market area as Latah County. They have been exposed to the same excessive media coverage, have proximity, and share the same pressure to convict that exists in Latah County. Even the two counties combined do not reach even a third of the size of the available jury pool in Ada County. The residents of Nez Perce have been exposed to 36% of the total media coverage, and more than 10 times more likely to encounter coverage as compared to residents of Ada County. Vetting are proposed by the state does not work. For decades, the courts have recognized this simple because a jury of 12 can be selected does not mean that the jury is impartial. You hit it right on the head, Ann Taylor. The requirement of the law is not satisfied by the mere impaneling of 12 men against whom no legal complaint can be made. The defendant is entitled to be tried in a county where a fair proportion of the people qualified for jury service may be used. A veneer from which a jury may be secured to try his case fairly and impartially and uninfluenced by a preponderant sentiment that he should be flung to the lions. Gee, I wonder if that's a jab at the Gonzaleses. This is why attempts to mitigate jury bias are best done when there has been less emotional investment and less publicity exposure regarding the case. Dr. El Alahai, Defense EXE, page 12, answers to the jury surveys in Ada County showed less emotional connection total. Contravention of Latah County, when asked how the community would react to a not guilty verdict, surveyors answered, mind you, this is the people in Latah County, the people in Moscow. This is how they answered on the jury survey. They would go on with their lives as always. I think they would take it well. I don't know if there would be a super strong feeling. That's what the jury is for, to decide based on the evidence. If a jury finds him not guilty, then he wasn't guilty because they fear the evidence at the trial. I think they would accept it rather than produce an expert who refutes the studies and opinions of Dr. El Allah. I can't even pronounce his last name. El Allah Alay Yai. I can't pronounce his last name. I'm sorry, guys. And Dr. Veronica DeHire. The state points to cases that have not analyzed such research. Judge Boyce in State versus Daybell explains how the case law dating back 50 years does not address such concerns for today. For example, one can only imagine what the justices who decided Urban versus Dowd 50 years ago would have thought about the concern today. When every potential jury has instant access to limitless media, literally at their fingertips on a handheld device, this is the first thing I would do, guys. I would, I would ban the access of, of cell phones, of laptops, of tablets. I would tell the jury they're not allowed to access anything on their tablets, laptops, computers, or cell phones pertaining to this case. That's what I would tell the jury. Sequestering of 18 jurors for 3 months is unnecessary and an unattainable. Determination of sequestering is not timely, as no motion for such is pending before this court, nor does the state produce details regarding costs to support the validity of its assertion that sequestering jurors from Ada County in Latah are more cost effective than moving the trial to Ada County. Idaho Criminal Rule 21A and Idaho Criminal Code 19-1801 were implemented for a reason. This case is that for a very reason. These three capital cases in Idaho have recently had a venue change: State of Idaho versus Lori Vallow, State of Idaho versus Chad Daybell, and State of Idaho versus Brian Drips. All cases stem from southern Idaho. The court in these cases all granted a change of venue with a motion supported by evidence of extensive media coverage. None of the cases presented extensive expert surveys, and none of these cases presented experts specializing in the science behind juror decision making. Of the three cases, two went to trial, and as the state points out, there were lines of spectators outside the courthouse, Ada County. Jurors in both cases provided in-depth media interviews post-trial and expressed that the Ada County court staff and marshals provided great infrastructure that made a big difference in their ability to withstand the significant commitment. This room, many bathrooms to make short breaks, efficient travel, and to and from the courthouse, with the security abilities to avoid the press and spectators by bust underneath the courthouse, and experience of the courtroom deputies provide security. Such accommodations are not possible in Moscow. The facilities do not exist to accommodate a jury of 18 for 3 months. In this case, where the public and press will be lined up outside of the exterior of the building. The president of courts, changing venue in Idaho, and the experience of Ada County have handled high-profile cases should be followed and used in this case. Mr. Koberger provided this court with extensive and unrefuted evidence. The evidence includes proof of excessive media coverage in Latah County that is both prejudicial and false, along with declarations of experts explaining why remedies other than a change of venue are not enough. Guys, I totally agree with Ann Taylor. A change of venue is needed. And if he's found not guilty, what they said in the beginning of this document could happen. He could be lynched. They could find him on the street and kill him. The parents of the victims could find him and kill him. Why remedies other than a change of venue are not enough. This evidence will be further developed at the change of venue hearing. The traumatized town of Moscow is understandably filled with deeply held prejudgment opinions of guilt. The surrounding area of Nez Perce County and Lewiston are not situated differently. The issue of venue reaches finality with a change to Ada County because Latah County mob mentality will never produce a veneer that results in a cross section of the community. She got it right, guys. Mob mentality. There is a mob mentality going on right now in Latah County, and it's all directed towards Brian. This mob mentality is directed towards Brian because they all think, they all believe what they see in the mainstream media. They all believe what they see on the news. They're already preconditioned to find this guy guilty, and it's wrong, guys. It's really, really wrong. Like always, guys, like, comment, subscribe to my channel, share my channel, hit that bell notification for any new uploads. And on my channel page, I'm being sponsored by W Energy. Make sure you click the link for W Energy. And at checkout, you will get a 10% discount just by using the True Crime Cult 162 at checkout. You guys have a good Thursday, and I'll see y'all later on this evening. Peace.
I never see the lights out. They got me overdrive. Fancy on a fast car. This is how you make me feel. Don't stress me now.